We've really saved the best for last, and that's Ronnie Krist, Ronnie, come on up here, please, who is really Clear Lake attorney, Texas attorney, United States attorney, internationally known attorney. And one of the things that I think is always impressive, if you go to the lobby at University of Texas Law School, there's a painting of Harry Reasoner, Walter Kronzer, Jim Perdue, and Ronnie Krist. Am I leaving somebody out?
Joe Jamel.
Oh, yeah, a guy by the name of Joe Jamel. We were fortunate to have Ronnie Krist come here. And Ronnie, if you look in your brochure about all the things and awards that he's done, the two that just stand out to me, which I and many other people have followed his incredible career, has been the rollover cases. He really established through Turner the importance of safety with rollover cases. And then, of course, all the space cases, the astronaut cases that he was able to bring and keep contractors and government contractors make sure that they're held liable for the pain and problems they've caused. I could go on and on, read that information, but we're getting down to the last, so I want you don't want to hear me, you want to hear Mr. Krist.
Well, today, the governmental contractor defense doctrine would somebody's glasses, would bar recovery. Matter of fact, that was one of the problems in the Challenger case, is that we were trying to hurry a settlement along because we were fearful that a case that was before the Supreme Court would adopt the governmental contractor defense doctrine and therefore bar us. The other side was equally in a hurry because they thought that the opinion would go against them. Well, we got it settled shortly before the opinion came out, and it was against us. And Thurgood Marshall said in the dissent, the Challenger case would have been lost had this opinion come a few months earlier. Well, thank goodness we rushed that out. I was listening, and wasn't part of my prepared remarks because I don't have any, but about this malpractice, how hard it is now. Look, I've been doing this 51 years. How many people in the audience are under 51 years of age? Would you raise your hand? Can you just imagine, I've been doing this, facing juries for longer than you've been alive. But I remember one, it was in Mark Davidson's court, and this doctor had treated his receptionist's son, who was kind of a semi-slow fellow, to say the least. And he sexually abused this boy during the course of treatment. And so I brought a lawsuit against him. And his lawyer, in an effort to get some coverage, let me be honest about it, I had also sued him for sloppy record keeping. And so they bring a doctor from Baylor, and he gets on the stand and he says, this is not real good record keeping, but in light of the relationship between the employee and the doctor, he kind of did this after hours, and it passes. Well, that kind of irked me that the doctor would say that, and that they'd even bring somebody up there. So I said, all right, doctor, now face the jury, if you will, and tell them whether or not orally copulating a patient is within the standard of conduct recognized by Baylor College of Medicine. He said, what? And I repeated it. About then, Mark Davidson said, we better go into chambers. And we went in, and he said something along the line to the defense lawyer, are you crazy? Pay this man. So they did. Now after that, and this wasn't part of anything, I just started thinking about about malpractice cases. I've handled Rose versus Doctors Hospital. You remember the one that said that the caps on wrongful death cases in the medical malpractice area is okay, is constitutional. But anyway, he had a lot of other people that came into his office, and he just seemed to couldn't resist. And rarely was he successful because the people, these engineers from NASA and other people, would just leave the office. And they'd come to me and say, this guy undertook to do this, and I stopped him. So I would just send him a letter, and we ran through all of his coverage. And finally, I would send him a letter and say, well, Doc, you've done it. That's all. And he'd finally, it was down to 10,000 a visit. And he'd send it. And this was many years ago. And I saw him in a restaurant last week. And he rushed up, how are you? Good seeing you. I did have occasion to wash my hands after I shook hands with him. Finally, and I'll get off this, I haven't ever spoken about this publicly, but there was a guy that came in my office and he said, this doctor, we'll call him Dr. D. Dr. D poorly calculated me when I went in for an examination. He said, I'm from New Jersey. And I said, okay. And I was getting ready to tell my secretary to send the usual time to pay letter. He said, now let me just tell you now, he said, it's okay with me because I'm homosexual. I said, well, that does put a new twist on it. He said, however, I also have AIDS. And I said, well, you better contact the Texas State Medical Board about that. Anyway, enough of that. They asked me to give lectures. They're called legacy lectures, speaking engagements, simply because I don't know anything about what's going on currently. Hell, I'm more worried about 3-putting 18 than I am about trying a lawsuit. I hope I'm not one of these guys that tries to define himself by, never giving up the ship. I mean, my practice has slowed down enormously, and as I was telling a friend the other day, you'd be shocked how cooperative my clients are. They don't call at all. I don't have any. There's nothing I don't turn anybody away because nobody comes. I will tell you that I started off as a tax lawyer, and I damn near went crazy. And then one day I went to hear a fellow that was on an Atlas seminar named Bill Colson from Miami give a speech. And I heard this guy give this speech, and I said, man, what he's doing seems like a hell of a lot more fun than what I'm doing, and also far more profitable. So I just redefined myself and went with a law firm in East Texas that could give me some training on how to try lawsuits, and thank goodness, because I've had a wonderful time since then. And like you, I went through the same things you went through, and that's this. When you first started, you wondered if you had it, if you were good, if you were average or better than average, because you really didn't know. And then you convinced yourself that you were, and the next step you were trying to convince your peers that you were a little bit better than just, you were okay, you were a good lawyer. And then as you won some more verdicts, you got more and more confident, and then another problem appeared. Many of us have had this problem where your ego would support a much greater talent. And I have good news. As you get older, your ego shrinks. And finally, your ego and your talent are congruent. That's where I am now. I don't think I'm anything special, and nobody else does, and that's just fine with me, Let me tell you, I set my secretary down, who September the 1st has been with me for 40 years. And I'm telling you, she is terrific. And honestly hardly ever been mad at her. She's been a psychiatrist for us. She's been a grief counselor. She's been a cheerleader. She's been a lot of things. But anyway, I got her and another lady who's been with us a long time, and I said, let's check out all the things that we did not have that we have now. And they made this list. We didn't have computers, and we didn't have correction typewriters. If you made a mistake on a brief, you did it over. One time, this secretary stayed at our office in the Turner case before the Supreme Court, which incidentally was 9-0 against us originally. And believe it or not, on rehearing, it was 9-0 in our favor. Never heard of it before or since. And incidentally, that was 37 years ago. When that case was tried, the states were equally divided on enhancement injuries, crashworthiness injuries. Half said they were a recognizable cause of action, half said they weren't. We had a Supreme Court then that was conservative. However, they were slaves to precedent. They're not like the ones we have now. They followed the law. Jack Pope, people of that stature. Wonderful judges, conservative but honest. We also didn't have, are you ready for this? Copy machines that were really functional. We had carbon paper, and we had the original in 5 was the order of the day. Your secretary type up original in 5 copies. When I first opened up, there was a realtor that was next to me in this strip center that I was in, and I made a deal with him where I could use his mimeograph type copy machine for so much a page. That also gave me wonder about the guy that was in my office at the time. I went in one Monday morning, and he was really happy. He said, man, this is right after Xerox had come out. He said, man, I found an office supplier that sold me all this carbon paper for down near nothing. It's stacked to the ceiling. That's when I started looking around the law schools to see if I could find someone to come help me. We had no, we had no voicemail. You just had to rely on a receptionist. We had no cell phones. I remember the first cell phone I bought weighed 20 pounds, and it cost me $5,000 back then. Adjusting for inflation, that must have been, $15,000 to $20,000 deal. No iPads. Investigators, you can find more in just a few seconds than previously. If you wanted to know where a juror lived or something about them, you'd have to hire an investigator. Hell, today you just push a couple of buttons and it tells you. We had no fax machines. I remember Pat Maloney in San Antonio said, I'm going to fax you something. I said, what the hell is that? And he said, well, do you have one? I said, I don't think I do. And my secretary said, we have one. And I said, well, if you send it, how do you know I'm going to be there? I mean, we didn't have fax machines. No Westlaw. It had no Westlaw. You just had to grind it out in the library. When I built a building, the last building, which I've since given to charity, but when I was building that building, we had the library on the second floor, and we had girders up there that would look like Adolf Hitler's dugout or something. It had to be so strong to maintain the weight to support the library. Well, hell, today, probably wouldn't even have a library, just have Westlaw. Which brings me to another point. We don't have PowerPoints back then. I call the way that many people try lawsuits today, trial by Star Wars. But let me tell you, I don't care. I think the spoken word still has a place. And I further will tell you this. I've never seen a computer or a PowerPoint that would make a juror cry. Yeah. And the spoken word can do that. I was given a speech years ago. We used placard boards back then. And there were cases as to whether or not you could carry the placard board into the jury room. And I was given a speech on one of the astronaut cases in Kansas City. And this woman before me, speaking before me, was giving a speech on the effective use of placard boards. Sounds like a hell of an interesting topic. So she trespassed upon my time terribly, leaving me about 10 or 15 minutes. So I said, you know, people tell me that exploration of the heavens is the greatest engineering undertaking in the history of mankind. I was allotted 45 minutes in an effort to explain that to you. But I've now been limited to about 15 by the placard board lady. And I think the job is just too big for me, but thank you for having me. And I just laughed. I was never asked back, I might add. But also at the courthouse, some of you might be old enough to have seen this. Elevator operators. The courthouse, y'all remember that? Also, smoking. Boy, I mean, I've tried cases where the judge was smoking, all the jurors were smoking, I was smoking. It looked like a damn casino or something in there. Today, you know, they put you in the penitentiary if you act like you're gonna smoke. Now, some of the things, though, that we had were rougher than what you guys have. Unanimous verdicts, contributory negligence of total and complete bar. And we used to all struggle trying to indicate to the jury that all these questions are important. And I remember, because you couldn't tell them the effects of their answers. I guess that's still the law. But I remember, you know, arguing, now, ladies and gentlemen, I can't tell you the effects of your answers to any of these questions you're asked, but let me tell you that each and every question is vitally important to the proper and just outcome in this case. Every jury would go on and on because we knew one contrib finding and out you go. Now, also, opening statements. I love opening statements. And the guy that we left out in the opening, Joe Jamel, and I have tried a lot of cases, several cases together. And he likes to do the voir dire, and I like to do the opening statement. Boy, I think the opening statement's great. And I've told him before, and both of the old Quinn cases that we tried, that if we haven't won this case by the time the voir dire and opening is over, we're not going to win it. Well, back in the day, when I started practicing, the opening statement was limited to reading the pleadings to the jury. That's a bad deal. And no video depositions. And you would have role playing, you know, somebody would play the role of the doctor and somebody would play the role of the lawyer, and you'd read the questions, and the lawyer up there trying to act like a doctor would read the answers. That's all we had. But stuff that was good now and then is cross-examination. I'm convinced that you guys win most or many of your cases, largely because of cross-examination. Cross-examination is simply, is the way I feel about it, simply a series of many jury arguments. They mentioned Turner, which was 37 years ago. So far back, it was the $4th million verdict in history of Texas. Boy, have we come a long way. But they had a smart aleck witness. His name was Ronald. I guess after all these years, I still remember that joker. He was really a smart aleck. And so I asked him, it was kind of a throwaway issue, really didn't matter, it wasn't the crux of our case, but I said, General Motors didn't put any foam rubber or any cushion type friendly place to collide. and the roof of their car and the headlining. Well, it was a structural case. That's really not an important part, but I thought I might as well just throw it in there, something else they didn't do. He said, I have you know, Mr. Krist, that sheet metal, it's been our engineering expertise, tells us that sheet metal is the finest absorber of energy known to engineering science. I said, really? I said, yes. I said, so let me see if I've got this straight. If you have the choice of being hit in the head with a foam rubber bat or a sheet metal bat, you're going to call on your General Motors scientific engineering and say, I opt for the sheet metal bat because it's the finest absorber of energy known to mankind. Well, that's such an easy one over the middle, but it illustrates the point that it's just a series of jury argument because you can suggest the answers and you can lead the witness. And I think that was one of the turning points because they realized that he was a fraud. Furthermore, he was a fraud because he said he that his area was the engineering concepts applied to the biological systems. Well, he ended up. I said, well, what college? What college was your degree in? He said, what do you mean? I said, well, was it medical school or engineering school? He said, I don't remember. Well, what it was business school. He majored in some sort of statistics. He said, I monitored medical school. That's whether that means your knowledge was never tested. You just walk in a class. Anybody can do that. Well, anyway, that's cross still is good, and everybody underestimates final argument. Well, not me. Well, I think final argument is so important. It's people think that that's not. I can't imagine why. And I've heard lawyers say, "Oh no, today's juror they don't respond to these emotional arguments." Okay. Well, if that were the case, I'd live in a much smaller house than I do today. My kids would have had to put themselves through college, I might add. But I think they do. Also on medical malpractice, and I didn't do a lot of medical malpractice work, but APIE versus Garcia this is why y'all ought to keep me out of the appellate courts. API versus Garcia was a case in the Supreme Court. They kept it 18 months until they got a new bunch of judges on the court, and then they ruled against me. But I'll tell you one thing that happened in that case. Fred Shannon was a lawyer who had been a federal district judge. He was defending the case. He asked for a continuance. And this years ago, and I said, well, Fred, I'll give you one, and I swear to God, this is the truth. I said, I need $500,000 now, and you can have your continuance. And he paid it. So even though I lost on appeal, the $500,000 was in the pocket, I have had a lot of people ask me about whatever happened to Susan Kerr. You remember the video sex tape case? Anybody remember it when another reason you ought to keep me out of appellate courts. 5 years before that case was tried, the Supreme Court, I think it was St. Elizabeth Hospital versus somebody, had acknowledged that negligent infliction of emotional distress was a viable cause of action. Now I tried the Kerr case, and suddenly they say that it's not. It has to be accompanied by some kind of physical injury. So I said, okay. They sent it back for retrial, and I told the lawyers we're going to establish that she had stomach spasms and headaches, and she had some physical manifestations, and they said, oh, to hell with it, and they just paid us. So we got all of her money, but it was not because of the help of the Supreme Court. But people have asked me, whatever happened to her? The stuff that you guys do and that I've done, have you ever recognized really how lucky we are to be able to do and delve into many people's lives and get paid for it? you know, and learn so much about so many different things. Susan it was just a heck of a deal. She was a great gal. And one of the funniest things that happened was we were on Larry King Live for an hour about that case. And this lawyer on the other side said, well, Mr. Krist is really kind of exaggerated about this girl. I mean, you know, she was a nice girl, but she wasn't just this princess that he's trying to make out of her. As he put it, he's constructed a halo over her head. Well, then they got to the call-in section of the program, and Sister Jane Meyer, who was the dean of St. Agnes Academy, called up the call-in section of the program. She said, Mr. Krist understated the quality of this child. Said she was one of the greatest girls we had ever had. And then this guy that was defending the case said, well, what do you think the bishop would think about you condoling premarital sex? She said, I'm not condoling it. I'm just saying to you that these young men betrayed her. They were duplicitous. They were mean. They were vicious. And it was wrong. And while I'm on that case, you'd think this is more of a conversation at a bar. I mean, a real bar than at a seminar. But while I'm on the case, she moved out to the Panhandle to get away from Houston, where some of these mean-spirited people kept calling her a porno queen and so forth. But after the trial, I took all of these people that were on our side. Hell, we had to have 5 bailiffs in that trial. I mean, one time, one of the defendants that I didn't like, there was 4 of them, but I really didn't like this one. And I had the habit of telling his lawyer in his presence that, you know, your client is really a sorry little chicken shit. Now, if the guy wanted to eavesdrop on my conversation with his lawyer, okay. Well, one day, his lawyer was late, and I couldn't resist. I was wrong, and I shouldn't have done it, but I said, you know, it's your day on the stand today, and I'm going to barbecue your little ass is what's going to happen. Well, no more did I get it out of my mouth than here he came. And I said, oops, I guess we're off to the principal's office. And he said, yes, we are. So we're going into this judge's office, and this is why I'm telling you all this commotion. Had the St. Agnes girls on one side and had the trust babies on the other. It was hell. And as I'm walking, this guy takes a swing at me. But he stops. It was the father of one of this kid. And I get to the end of the road, turn left, go in. And he said to me, he said, you really think you're something, don't you? I said, well, you know, look, this is not going to lead to anything affirmative. I started, and then he took a swing. Well, you all remember Seawood. How many remember Seawood, the bailiff? You know, he looked like a pulling guard for Green Bay or something. He was a good guy. Old Seawood was a wonderful fellow. And he blocked this punch. And I said, Seawood, did this man strike me? He said, well, he tried to, Mr. Krist. And I said, well, I just wondered. I've never been hit by a 155-pound man wearing Gucci loafers. I didn't know if you could feel it or not. That really got him steamed up. And then after that was over, I took all these children to a hotel suite up at Ritz-Carlton, and had this big suite. And I said, now look, y'all can have all the cheeseburgers and beer and stuff you want, but don't leave here and go out and mingle with all this other bunch, this opposing group, because, you know, we don't need any more problems. While I was up there, and before I left, which was early in the evening, I got a call from the defense lawyer's office. And it was a secretary. He said, Mr. Krist, wasn't that tape that you provided to this firm under court order not to be viewed by anyone but the experts? I said, that's right. She said, well, they're in here watching it. I said, really? I said, yes, well, I'll be out to see you tomorrow. I got her address. Then I get a letter in the mail, and in that letter was a memorandum from the trial lawyer to Jay Hirsch, who was the senior lawyer in the firm. Jamie Drabeck was the trial lawyer. And in it, they confessed that they'd watched the tape, and they listed who all had watched it. So I called up their senior partner, Mr. Hirsch, and I said, Jay, there's a rumor circulating that you all watched this tape. Oh, well, that's not true. The memo was addressed to him. I said, well, my client would feel better if we just had you say that in court, formally, and just put it away. He said, okay. So we set up a hearing, and we go into court, and I said, put him under oath, got him on the stand. Mr. Hirsch, is it not true that some of your lawyers, after the verdict was rendered, were drinking champagne and watching the tape? And he said, no. And he said, I resent you even suggesting that. I said, well, if you resent that, you're really going to resent this. And I pulled out that memorandum. I've never seen a witness on the stand get more excited than Jay did when we introduced that memorandum confessing that they'd watched the tape. But anyway, whatever happened to Susan, NBC wanted to do a Monday night at the movies thing about her. We didn't do that. And she finally moved out to West Texas, and she was going to marry a coach out there in one of those small communities. And the school board said, oh, no, we know about this girl, her reputation. It was just such an unjust deal. It really was. She was a really, really great gal. And then she finally got married, and her family lived in kind of a compound, kind of like that old television program, whatever it was called, with Hoss Cartwright and all of them. The father and the two brothers, they all had their houses out there. And her husband, they were prosperous, had a big ranch, had four boys. And her husband was flying in from a cattle auction. He flew his own plane and he hit a high wire, crashed and was killed. So once again, her plate was just really full. I haven't heard from her in a while. Anyway, I would suggest to most of you who are probably all personal injury lawyers that there's a lot of other things you can do that will make you money, especially as it gets tougher and tougher to represent plaintiffs. There was a case I handled called Vickery versus Vickery, which was a bill of review, a divorce case that was fraudulently, the original judgment was fraudulently executed. They told this woman that they were going to get her a lawyer. They needed a divorce in order to protect their estate from someone who was going to sue them. And that lawyer was in cahoots with Mr. Vickery. And after the divorce judgment had been entered, 7 months went by, and then the sheriff showed up at her door and kicked her out of the house, and told her that little paltry sum, $500,000-$600,000, that they had given her in the divorce was really all she was going to get. And I went all over town looking for a divorce lawyer to take this case under a bill of review, and I couldn't find anybody. So we took it ourselves. Berta Rayburn, who was a tough old gal. Y'all remember Berta Rayburn?
Oh, yeah.
A divorce lawyer. She was tough. But I don't think Berta was used to trying cases against heart lawyers. I just don't think she did. I respected her. She died shortly after that trial. She told me during the trial, she said, damn, you're killing me. And I guess I was. Because she died. But anyway, I did win for Helen the annuity, which he had all of, Well, we got her $13 million and $60,000 a month on that annuity. And every time I get my paltry share of that 60 grand a month, I'm sure glad I went over to the divorce court for once in my life. Well, I guess that's about the size of it. I've enjoyed my life as a lawyer. I can't imagine us doing anything that would be more fun, and being able to help people make a good living at it and contribute something to society that all of you I know do. And you know, we hear all these damn lawyer jokes. Listen, I'm proud of being a lawyer, and I'm proud to be in front of you guys. Thank you very much.
Ronnie's going to hang around for a minute. I was telling you we're going to save the best for the last. And we have a choice of hearing me speak for 30 minutes on grievances, or you can go have a drink. Let's see, go hear me talk or go have a drink. Well, or you can promise that you'll go to the website, read the stuff that's posted there.